ladies and gentlemen. Daniel Forouzan here with the next episode of the Schmoozin with Forouzan podcast. Very excited as usual. Look, all these guests are near and dear to my heart. And now we have here Mr. Kelly Knight. I was really excited to have Kelly on for a few reasons. A, I have nothing but respect for the guy. I've had enough conversations with him. He's been on panels for the West Side Bar Association. Kelly's the kind of guy who knows his stuff. And what's interesting is he's had quite an interesting array of different jobs in his legal career, ranging from defense side to plaintiff side, and now mediator. And I think that's wonderful because it gives you this plethora of information that we can go through and various perspectives that we can gain. So, Mr. Kelly Knight, how are you today?
I'm doing well. Thank you. A little under the weather, but I'm here to schmooze with the Forouz. It's so nice to see you doing what you do, and knowing when I first started talking with you in some mentorship years ago, when you first started doing plaintiffs employment law, to starting the West Side Bar Association and having these mega legit conferences with these superstar lawyers flying in from all around the country, doing and bringing people together. It's pretty amazing what you've done. So congratulations to you.
I appreciate that. It has been a while since we met at that sushi restaurant in the Valley a long time ago. So, and you've come a long way as well, my friend. Becoming a mainstream mediator in one of the larger organizations is not some small achievement. So obviously you certainly know what you're doing. Let's just go into a little bit of details into your background. I don't usually like the Boris stuff. Oh, what school did you go to? No, but your background is actually interesting because you did both sides of the aisle. Is that correct?
Yeah, I'll try to fly through it, and you just stop me if you want me to elaborate, because
Sure.
If we did a detail, it would take kind of a long time. I grew up in a poor part of Sacramento, South Sacramento. I never knew a lawyer. I had no visions of becoming a lawyer. It wasn't even an idea for me. And at my last year of Cal undergrad, I needed one class to graduate with an economics major, but I needed a full load to get financial aid to pay for housing and everything. So I was taking a couple extra classes, and one that I took because it sounded interesting was an ROTC course called Military Law and Ethics. And in that course, in comes they had guest lecturers, and there's military officers and judges coming in, and we had this guy who came in who just pumped us up so much on those. It's like, if you've ever had a class where you just audited a class and it turns out the professor's like super amazing and it turns you onto a whole new field, that's what that was like. One of those really uplifting kind of guys who said, hey, if this stuff sounds interesting, come talk to me after class. So I did. And I thought, man, I think I want to do that. And I think I want to do that as a JAG officer. So I actually went into law school intending to be a military lawyer. I grew up largely on an army base in Korea.
Oh,
actually, the recent Itaewon tragedies hit a little close to home for me, because that was the area that I was in, right outside of the military base there. And growing up on the base, it was like its own little city and community. And there was something about being a part of that that I missed. My mother's husband was a retired lieutenant colonel. My mother worked for the Army her entire life as a civilian. That was the world that I was around. So I thought I was going to graduate with an economics major, go into investment banking for 2 years, and before I go insane, then go back to school, get an MBA and do the traditional finance route. But when that started to get real, as I was about to graduate, I thought, I don't want to go. At Cal, we called it being a suit. I don't want to go be a suit. My whole life is to make money for other people. And I thought, here's a way to do something else that's kind of noble. And so my mom was working near one of the biggest, perhaps the biggest military base in the country, Fort Irwin, outside of Barstow at the time, in the contracting office. So she works with the lawyers. I said, Mom, can you hook me up with the JAG lawyers? So she did. I went in, I got a meeting with them, and they said, hey, come back next week. We're doing courts martial. So people I talk to, being a lawyer, it's nothing like on TV. It's just pushing paper. Right. So I go to the courts. It was straight out of Hollywood. Witnesses crying on the stand, cross-exam, 2 criminal cases I sat in on back to back. The judge was cool. I got to talk. The judge brought me back in chambers, and we talked about what happened in the trial. And I asked, why did you make this ruling and that ruling? And I saw that the work of the attorneys directly affected people's lives. Someone's liberty, right?
Yeah.
Someone's liberty. And I thought, what an amazing, noble job that your efforts literally can mean freedom or incarceration or lengthy sentence or short sentence. And so I decided to do that. I was, so it was too late to apply to law school for the year. So I spent a year as an insurance adjuster at Liberty Mutual in Sacramento. That was my first job out of Cal.
PI adjustment?
I was doing workers' comp, actually, much more complicated.
Okay.
That was just luck. And it turns out it was an amazing foundation for what I do now. Right.
Tell us about that.
Because I got, all the, I was a lower end guy, right? But we had all the way up to the massive catastrophic cases all on the floor. And I was talking with those colleagues too about what they did. So we were in a team. I had my level of authority. If I needed more, the team lead had his level of authority. Great guy, Richard Dawson. And then if we needed more, down the hall was the team manager. And above that was the floor manager. If you had to go to the floor manager, you better have a good reason, right? And so that layering and how we approached cases was very interesting and very eye-opening on the inside of at least one company's insurance practice, right? We'll talk about how that plays into now when, litigators are bringing cases and there's an insurance dynamic there. But while I was there, then I took the LSAT, I applied to law school. And I got in, and as soon as I got in, I'm like, I got to go work at a law firm. Like, I need some experience before I go to law school. So I just so happened to luck out, and I got kind of like an internship with the then president at the time of the Capital City Trialers Association, kind of like the CALA of Sacramento.
Interesting.
And it was remember, I'm from South Sac, and it was one guy and a secretary, a litigation assistant, making $500,000 a year, working 30 hours a week.
Wow.
Right. And I'm like, oh my gosh, this is possible. Right. And helping people. Right. So that opened my eyes and planted a seed big time. I want to do that. Right. I didn't know that that's something possible for a kid like me. So I made some friends in law school, and the idea was, I went to USC and we all had massive debt. Right. Yeah. So the idea was go get trained. Right. Actually, I joined ROTC in law school. I'm still intending to be a JAG lawyer, but I went to airborne school my first summer. Like, I was in it. Right. But the events of those times, this was 2003 to 2006, a lot going on in the world with the U.S. military. The events of those times had me question what I was doing. And so I changed course. My best friends, or two of my best friends from law school, and I wanted to go become plaintiffs lawyers. And so we made a plan. Let's go get trained. Let's pay down our debts. And then we'll be Mitchell to Good and Knight. Well, Mitchell had to move back to Canada to take over the family business. And DeGood was married, I think had a baby on the way before law school was over. So it was just me. So I went to a big law split off and got really lucky. I was the first junior associate hired as this partnership group was splitting off. And I was thrown into the fire and did depositions and all kinds of stuff and went through two major trials. One got the Daily Journal Plaintiffs Verdict of the Year award that year, between, big business litigation, right? And as soon as I was able to, I'm like, I'm okay, you guys aren't going to do it. I'll do it myself. Law offices of Kelly A. Knight, right? Here we go. And I went off on my own. And I was taking everything. Plaintiffs, employer side advice and counsel, PI, small time PI. Thank goodness to, folks in CALA and mentors that I had to walk me through how do you handle, fender bender case? How do you handle a soft tissue case all the way up to catastrophic injury, right? But that's the gist of it. That's how I got started, from figuring out I wanted to do law and getting into law for one reason, changing course. There you go.
Okay, so just to be clear, just to get a big picture. So you're talking about defense side adjustment for workers' comp, and then you go into private practice where you may have had defense, but you also had plaintiff as well, correct?
Right.
So you've had a nice view from both perspectives. And look, I know I've had quite a bit of, I'm a plaintiff's attorney exclusively, but I've had quite a bit of training from defense attorneys. And it has certainly broadened my eyes. I came to realize the defense bar doesn't always value the same things the plaintiff bar does. And the defense bar is also not impressed as much by lawyer awards and billboards. And I just follow my Instagram if you're curious about my opinion of lawyer awards. But they don't fall much for the marketing that sometimes goes on the plaintiff side. So, now you're a mediator, which is a big deal in my opinion. My question for you, and we're going to dive into the adjustment and the insurance work comp adjustment as well as the plaintiff work. But generally speaking, in mediation, what are the trends that you're seeing right now in 2022?
Well, it seems like ancient history, but it was just 2 years ago, right? 2.5 years ago that the pandemic hit.
Yeah.
We didn't know what the heck was going to happen. All of our, at least the colleague that I've spoken with, I think all the mediators have similar stories. All the mediations came off calendar, right? It went from, oh, whatever, this is no big deal to, oh my God, this is a serious, like, people are going to die, right? And we can't be in person anymore, and the lockdowns and everything else. And we didn't know if this was gonna work, but Zoom mediation took off. A lot of people were holding out, waiting for us to get back to normal, meaning the old normal. There is no old normal anymore, right? And so people realized we got to start pushing cases forward. And it turns out that if you're one of those holdouts, okay, I get it. You have your way of doing things. You know what to do. But let me just offer another view of it from the mediation side. Zoom has been amazing for settlement for many reasons. Okay. First, we know if I cite psychological studies, mediators, people who are like me, like we read this stuff, right? It's undergrads in a lab for free pizza and $10. I mean, how much can you know what I mean? Psych studies, how much do you put in it? But we know that people are easy to and more willing to compromise when they're comfortable, right? There's even a weird study about people are more willing to compromise and easier to deal with when they have a warm drink in their hand versus a cold drink. How about that? Interesting stuff. So I'm sure you know the feeling of being stuck in a mediation office at 10 p.m. at night and frustrated and pissed off and tired and uncomfortable in your suit and hot because the AC went out on the floor, 4 hours ago. And, it can be a very uncomfortable situation and kind of a terrifying situation for example, a sexual assault victim who's got the perpetrator down the hall, right? I've been there where the plaintiff didn't want to leave the room even to go to the bathroom all day, terrified that she might see her assaulter, who was a defendant in the case, right? So we can avoid all of that with Zoom. The other thing is we have drastically more participation from the decision maker side, drastically. On smaller cases where we'd have one defense attorney in person, right? Maybe a local company rep. My communication with the decision maker, whether that's an insurance representative, whether that's a CEO or a CFO or whomever it is, was whatever the defense people allowed it to be. Now, I could insist, I got to talk to these people, but hey, unavailable, right? I mean, really, it's their call. And sometimes I get a couple phone calls or whatever it is, but the person's not there all day. Now, I've got insurance adjusters with me all day. I've got CEOs and executives in other countries. I've had Greece, Australia, France, China, many other places, right? They never would have flown out for, $100,000 employment case or a 200 or whatever, we're not talking, massive lose the company type cases. You wouldn't get their participation at all. So we have much more access on Zoom, right? People can turn on the camera and, kind of follow along as they work, right? So there's that. And I really think the level of hostility has gone down in mediation compared to before. I mean, you used to be able to have some theatrics on just walking out, right? Everybody pack up, we're walking out, and you got to walk, even if it's the long way, you got to walk the long way so you go by their room and they can see you through the glass and know you're walking out, right? There's none of that stuff anymore. They threaten anyway. I'm going to walk out. Like, where you walk? Stop. Where are you walking to? I'm going to turn off the computer. I'm going to call you on your cell phone. Well, I'm not going to answer it. we can eliminate a lot of that stuff, right? Of course, we lose some things too, right? We lose the in-person touch. How much is that? What is that? Is that a game changer? Is that the difference between settlement or not settlement? I think in the vast majority of cases, it's not.
I would agree. I would agree with that.
Right. Now, there are exceptions, right? Had a case in person where the defendant who was being sued was a buyer in the purchase of a very big medical facility, right? It was a big deal. And during the due diligence, some stuff came up and they said, we're not buying this. We're backing out. Right. And they all, we're going to sue you. We're going to sue you. So they show up. I get a very short cursory brief from one side and no brief from the other side. I go on, well, we're not here to settle the case. What are you here for? We're here because our dispute resolution clause says we have to attend to mediation before we can sue. So we're just here to satisfy that, and we're going to file the lawsuit tomorrow, right? We're in person, mind you, right? By the end of the day, both groups of people, their attorneys and accountant and reps, they're all in the same room together. The deal's back on, and they're talking, and they're working out a second deal, doing a second deal, right? I mean, it's rare, right? The vast majority of my cases are employment and tort cases of some type, or class actions. And frankly, a lot of those are really about money, right? Especially the class actions, largely, not all of them. Some people are bringing cases to change a corporate practice or whatever it is, but it's largely about money. And for those cases, we are fine on Zoom, right? In fact, I think we're better because of the participation that I mentioned. So I think the trend is we keep waiting for the world to go back and everybody to go back in person. It ain't happening. And there are some of my colleagues are doing in-person mediations again. We have a high-risk household with my wife is immunocompromised. And this has been a blessing given the pandemic, right? I'm very COVID cautious, right? We don't leave the house for discretionary things, only when we have to, right? Doctor's visit, we try to get the first appointment of the day so nobody else has been in the office. I mean, we are very careful. So this has been a blessing for us that I can still do this work and not endanger my family, right? Because if heaven forbid we had COVID here, I don't know what would happen, right? But it seems that the consensus for just about everybody I talk with, including on the defense side, the insurance carrier side, is it's so much more cost efficient to do this. Right? It's so much more efficient to do it on Zoom. So that's the big trend. I know you want to talk about some other things in the law. We've got, for those who do employment law know, every year it's some big thing that changes everything. Right? So I just wanted to go back to something where we're talking about my history just to make sure people understand. When I was working in the big law split up, I did employment law also, some, both defense and plaintiff. So it wasn't that I first started as a solo doing it. But anywho, what do you want to talk about?
Yeah, I would second all of that. My experience with, I thought Zoom depositions and Zoom mediation, when I first heard about it, I was like, oh, this is a joke. I got to be in front of the deponent. I have to see him squirm or her squirm, whatever it is, all these various things. And I have certainly had an about face on all of that. With regards to mediation, I always felt, look, it's a connection between the lawyer and the mediator. We know each other well enough at this point, or, we're all professionals. We kind of get how that cohesion works. And the rest is up to the lawyers to figure it out with their clients, where if you have client trust, I don't see why Zoom is an issue at all. I actually think it's quite collaborative. You can have all your clients on the screen. And goodness gracious, the circumstances, now that I look back on it, in order to do something via Zoom, whether it was a depo or a mediation, you have to get all the lawyers there. Everyone has to be at the same time. Everyone's suited and booted. You got to pay for the valet.
Suited and booted.
Yeah, like all this. Don't get me wrong. I'm still dressed up for a mediation or deposition, not just from the waist up, the whole body. I do the whole body, just to maintain the tradition of dressing up. But wow, that was a lot we went through to get people to a specific place when all we have to do is just have a Zoom.
Turn on your computer. Yeah.
Yeah. Client has to show up on time. Client's lost. You have to get them directions. That's all gone now.
Yeah.
Link. And I also found that just the amount of paper that I'm not wasting.
Mm-hmm.
Imagine I have a case with 5 or 6 defendants. I have to make 5 or 6 sets of 100 pages,
Yeah.
500-600 pages of exhibits. And then you realize, oh, that other exhibit I didn't print, or, oh, I didn't even realize that would be an exhibit. Now you have to pause the whole darn thing, go and print it out. I'm having great experience sharing things using Zoom, PDFs in real time. You can go on Google Maps and ask the deponent questions. You can zoom in on Google Maps. The deponent says, no, I can't see from that side. No problem. Let's cross the street on Google Maps. Can you see from this side? And it works. And it works. So I'm with you. I'm surprised we didn't get here sooner. Let's talk. That's the meta. Let's talk about sort of more tactical, specific types of things. I'm going to start with the big question, things you wish you knew as a litigator that you now know as a mediator. And then let's hop into more specifics like demands and briefs and evidence. But let's start with the first question. Now that you've been mediating, what do you wish you knew back when you were a litigator that you didn't know?
That's an interesting question. For me, running my own practice, I always struggled with balancing and managing everything, right? There's never enough time in the day. Engaging with the other side way more right up front from the beginning. I wish I did it a lot more. I did probably more than a lot of other folks, but not enough. Not enough. And I see the lawyers coming to a mediation. They've never met. They've never talked, right? I've had lawyers refuse to talk to each other and meet each other. And they don't see each other as human beings, just as enemies, right? Now, you'll have the bad lawyer and the bad apple here and there who's just absolutely horrible to deal with, right? We all know those. Trust me, the mediators know those too, right? But, most of us are doing a job. And you got clients, you got to do a good job for them, right? But when you're in litigation, when you're at mediation, everybody's got a problem. And we all have to work together and cooperate to solve that problem, right? There's one way to look at a plaintiff, a human being plaintiff in a case, personal injury, employment. They've got a problem too. They were wronged, but also they're in litigation, right? And let's not talk about the simplest of cases, but let's talk a case that's all dependent on witness testimony over the course of years. And you got to do 15 depositions, right? And you can easily be out of pocket 50 grand, 100 grand. You get to experts and all that stuff. I mean, very quickly, right? If you're really going to go all out, that's a problem, right? That's a problem for everybody. We don't want to do that if we don't have to, especially if the case doesn't make sense to do that. And so mediation is a way that people can try to not have to do that and take control of the outcome rather than just fighting and fighting and fighting. Everybody knows this, but getting back to engagement, to treat each other like human beings, we can do that a lot easier in mediation than when we're fighting about stuff, right? In active litigation. And I wish I had that concept in my brain a lot earlier.
Interesting. So let me ask you this, because we've all heard, how many events have I been to where the mediator, the judge, even opposing counsels point out that rapport between the parties is irrelevant. I believe that. I try my best. I wouldn't say I always succeed, but I do try my best to maintain that connection with opposing counsel. But there's also a part of my brain that just says, hey, look, the facts are the facts. But I can't disregard the fact that you're bringing it up and others have brought it up before. Mm-hmm. How much of an impact, in your opinion, now that you've seen it from your side as a neutral, how much of an impact are we talking about rapport between counsel has on the effectiveness of mediation?
I mean, of course, it depends on the case, but I'll just give you some examples of when it really mattered. There was a case where a very fine lawyer, whom I like very much, was really pressing hard, going all out. Many depositions taken before mediation. And they could have mediated way before half the work had been done. I think everybody knew enough, but was going all out and was really pushing a much higher value that the other side would never pay. And frankly, I thought was just outrageously high, but he was committed to it. It wasn't some negotiation tactic. And I pulled him aside and I said, why are you fighting this hard on this one? here's the issue, and here's this issue, and here's this issue. We know how this is going to go. The upside's not there. And it turned out, this wasn't conscious for him until we had this discussion. It turned out he remembered being beaten by this defense lawyer 10 years before and really just wanted to prove himself and get back. So I've got you on this one, and was over litigating the case, really. Right. There's another one where, a very short example. There was a mistake of fact going into a class action mediation where if something was done one way on the ground, there was big liability. And if it was done the other way, there was no liability. Right. And that one issue hadn't really been identified very well or investigated before the mediation. It came up at the mediation. The two lawyers on opposite sides have worked together many times, respected each other, trusted each other. And when the other lawyer, the defense lawyer, said to the plaintiff, this is not how it was done this other way, the lawyer actually said, now some of your listeners are going to say this is absolutely nuts, but it's a real example. He said, if she says that's how it was, I believe that's how it was. She'd never lie to me.
Interesting.
Right? And case settled. $1 million difference on that issue. Right?
Interesting.
So it can be everything, like in that case, right? And sometimes it doesn't matter as much, but it can matter a lot, right? It can matter a lot.
All the defense attorneys who are listening right now, like, see, I told you, and all the plaintiff attorneys who are listening right now, like, wait, what? What's going on here? I can appreciate. I mean, I remember I was at a Los Angeles County Bar Association event, and it was at the courts, and there's a judge, and the judge was echoing the same things that you're saying, and his recommendation was have a beer with opposing counsel. I mean, good luck. Everyone's pretty busy, but that was his recommendation. He said, just like you did, have it early. Start that process early, not at the point where you're already at each other's necks. Start it before.
I was speaking on I think it was the Daily Journal conference a couple of years ago. I forget what it was, but there was a defense lawyer whom I met for the first time there who said every case she has, she invites the other lawyer for coffee. She says, if you're busy, I will come to your office and bring you coffee. Let's just sit down for a couple of minutes together and not talk about the case. Right. And I thought that was pretty amazing. Right.
Yeah, that is an interesting thing. I mean, look, as a plaintiff's attorney, the first thing that runs through my mind is what does she want? If she wants to come have coffee with me, like, what are you trying to look at here? What are you trying to figure out? But look, it could just honestly be a rapport building tactic, which both parties should participate in. I know I had one example recently with the opposing counsel wanting to get me on the phone. We were the early stages, and phone call, I was fine. The phone call then escalated to a Zoom video call. I was like, wait a minute. Could we, I thought we were having a phone call. And they said, no, we like to do Zoom videos. It's more personal. And
yeah,
I said, oh, okay, that's an interesting way of doing it, doing a Zoom video rather than going in person. So that's something I experienced, but that is certainly interesting. In fact, I have a new sexual harassment case that I have coming up. And because of that, I'm going to reach out to opposing counsel and just have a conversation with them. Let's talk about mediation nuts and bolts tactics. What about, in terms of what you're seeing right now, what's going on with demand numbers and offers and counter offers?
If you will allow me to segue from what we just talked about.
Sure.
The engagement of the attorneys, and part of the reason why I brought it up is something I wish I had done better earlier on. Right. I mean, we don't know. We're trained. I was a big law split up guy sitting in an office, right? When the senior partner told me law is not done in the office, get out on the street, meet people, talk to witnesses, right? I remember that very well. But engagement with the other lawyer is critical to many mediations actually working, right? Right from the beginning, when do you mediate? What info do you need to mediate? Can you talk with the other side about, hey, here's what we think this case is about? And he says, here's what our defenses are. Okay, what do we need to evaluate our sides, right? If you're looking for, and I even think you should consider on the plaintiff side talking about how you value the case. Because that raises a lot. How many times I read briefs I got, this is a multi-7-figure plus punitive damage award case, and the defense brief says this is a frivolous case. We're really coming here because it costs the defense, right? And I'm like, you guys haven't talked to each other at all, right? And nor have they done the homework necessary to know. When I go to the plaintiff's lawyer, let's say the defense has interviewed a bunch of the witnesses to certain alleged events, and they say, listen, seriously, none of these people support what this person's claiming, right? And they're writing memos to their carrier or whomever. They're not going to suddenly pay $1 million or whatever it is, many millions on a case that, the plaintiff's lawyer thinks, oh, they know how bad it was. They're going to come ready to pay. Well, you don't know. Maybe a witness lied to their own people too. Who knows? Maybe your own client's lying to you, right? But when you talk to each other, and of course, you're going to have some gamesmanship about it. You're not going to be totally clear on what you want and all. Sure, right? I'm not saying tell them your bottom line up front before you ever go to a mediation, right? But when you start to let them know, hey, I really think of this as this kind of case, and the other side says, oh, wow, we're not seeing that at all. You can talk about, well, is it the right time to mediate? What do we need for you to explore on the plaintiff side? Whether you really can prove that case. Okay, I need these two people's depositions to start. And on the defense side, right, what do you need to examine your risk exposure? Plaintiff's deposition, some medical records, whatever it is. Tell me who the key witness was to the event. What do they say? If you talk about that way ahead of time, you can be much more successful in the outcome, right? Or in the mediation, right? Save you money, save you time. Not have to then litigate on and go scorched earth afterwards because you're all pissed at each other. Why'd you waste my time? No, why'd you waste my time? Right? Also, you can, there's this, I'm speaking at the LACPA panel in December, and John Barber is going to be there, and I'm going to tell him, John, give everybody your memo. He has a little memo to some of his lawyers about what to do a month before the mediation or 2 months before the mediation. And they don't all follow it, but some of them will tell the plaintiff's lawyer what they need and when. And if you're a plaintiff's lawyer, you should ask your defense lawyer counterpart, hey, we got this mediation coming up in 4 months. What do you need? When are you writing your memo to the carrier asking for authority? What black holes do you have in that we can help you fill in? Well, I'm unclear about this, and I'm unclear about this aspect of damages or whatever. Okay, let me address that with you, right? That's the time to figure it out, right? Of course, you're on the plaintiff side. You want them to pay you money. You got to show them and let them know why they should pay you money way ahead of time, because that's when a lot of decisions get made, way before the mediation. That all comes back to engagement, right? Engaging with the other side. So that's going to be my diatribe, my recurrent theme for the day.
It's an interesting thing. So my brain right now, I have a mediation in February. Really, it's March, late February, early March. Personal injury, catastrophic injury. I have spoken. I 998'd one of the defendants. Of course, I have like 5 defendants in that case, but I 998'd one of them, and I didn't expect them to cave on the 998. We had a mediation scheduled afterwards. Of course, now arguably, I think personally, inarguably, the policy is open, but they knew they had a mediation. Why pay now when they can pay later and possibly pay less? Who knows? I understand that. But what I'm thinking is I've been trying to get hold of the defense attorney to have that conversation, the exact conversation, like, what do you guys need? I see you didn't accept my 998. What is it I can give you to? The defense attorney doesn't return my calls, of course. In this particular case, he's been very non-responsive. However, I have rapport with the adjuster. I've spent at least 25, 30 minutes on the phone with the adjuster. So it's not out of my mind to call in the friendliest fashion and just be, hey, look, if there's anything I can give you in anticipation, please let me know. In fact, I think I might do that. So I appreciate these podcasts are very helpful. You learn a lot of little things in the way over there.
Be careful about, pre-lit is one thing, but represented party. Yeah. Right. Once the defense attorney gets assigned. But yeah, sometimes you'll reach out and they're not willing or not able because they're so busy. Who knows? Right. But you just do the best you can.
Yeah, absolutely. I mean, she calls me all the time, to be fair. Okay. So let's talk about, are you seeing, let me go big picture here. And this is like a big picture mediation thing. This is not so much a trend as it is a generalized question. I know plaintiff attorneys who like to make preposterous demands, and they come down $1 million for every 225,000 the defense comes up. All right, that's one thing. And then is from my defense side training, they always said, look, we take you more seriously if your initial demand is reasonable. It's not something in the stratosphere. What is your take on that? High demands and various things of that nature.
Well, it can lead to a lot of confusion and miscommunication. Back in the day, you'd make a demand and the defense would think you wanted just a little bit less than half of that. And now, different people think different things. I had one person be pissed off that the plaintiff wouldn't accept some number because they made some demand. They said, yeah, and usually they want to take 20% of their opening demand or 15%. I'm like, where'd that come from? Well, that's how this has been going. There's so much miscommunication about this kind of thing. Again, it goes back to engagement, right? The very, very high, kind of ridiculous numbers, it doesn't do anything for anybody. It just wastes time, right? Going to demand $4 million on a case that'll settle for $250,000, right? Now, if you really want $2 million on that case, or 1.5 or something, or one, okay, right? Okay. But have you done all the work to make it that case? If you have, and they're just not willing, hopefully you've engaged up front, and maybe you had a mediation scheduled, and everybody can say, you know what, let's continue it, right? It doesn't seem like we're going to be successful. It seems like we need whatever. Maybe we need expert depots, right? Whatever it is. But if it's just the coming in, making outrageous demands and telling the defense what the attorney's fee award will be after the trial that hasn't happened yet, it doesn't do anything for anybody other than make mediations go long.
Yeah.
Right. So there's my thoughts.
Okay. Yeah. I'm sure there's a defense attorney out there who said Daniel does make outlandish demands. Maybe not as much as maybe most of it. To be honest, I purposefully try not to throw those. I was in a mediation one time. I had a co-counsel at the time. The demand was $3 million, and we ended up settling for $250,000. And I thought to myself, what would have $1 million demand done any differently? It might have actually gotten out of here quicker. If the expectation was just $250,000, why are you doing a $3 million demand? But okay, whatever the case may be, I try to be more reasonable in my approach, give myself enough breathing room, but I'm of the same mind. What about briefs? What are you seeing?
Dan, I think that this issue of high demands is tied to a lot of behavior in mediation based on fear. I don't want to leave anything on the table. I don't want to look weak. I want to come in strong. People say, we got to come in strong. But that doesn't look strong. It looks ridiculous, right? But a lot of it's fear-based, just like relying on mediators' proposals all the time, even when you don't need to. Remember, I had a plaintiff's lawyer at 11 o'clock in the morning, like during the second caucus, tell me, we got to settle this case by mediator's proposal. I'm like, how do you know? Right? Because a lot of people, they actually plan for that. That's their negotiation style. We stay high forever. We come down to some artificially still high number and try to skew a proposal upward. I want to share something with folks who do that. You often leave money on the table that way, right? You often leave money on the table. You're putting it in the mediator's hands. Oftentimes there's a range that both people would accept, right? Let's say I'll make up numbers, right? The plaintiff's bottom line is $10. They want $10, but they're saying they want 15 as a bottom line. But the true bottom line is really $10, and the mediator knows that. And the defense says their top dollar is $8, right? They never pay you more than $8, but the mediator knows that their top dollar is really $12. Well, now we know a mediator's proposal between 10 and 12 is going to work, right?
Yeah.
What does a mediator do? Where? 10, 11, 12, 10.5? Split the difference? What? We're human beings too, right? This person really needs the money, right? We're not supposed, I was about to say we're not supposed to, but what is the supposed to? California, we don't have actual mediation regulations about what our ethical duties are, right? So it creates some issues. Maybe you could have gotten the $12 if you demanded it at the end of the day and said, no, this is really what we want. You can pay it or not. It's okay. Maybe they would have paid it. I already told you, we know they'd paid 12. Maybe you would have gotten it. So of course I do proposals like everyone else if I think they're going to work, but I want you to know that sometimes that might mean you are because you're not making decisions on your own at that point, right? Of where the decision point is. You're letting the mediator say, this is the decision point, yes or no to this number. And sometimes you could have had a better decision point, right? If you took control, but it's fear-based. I don't want them to know that I would go this low. Why not? Because they're going to try to negotiate, we're not going to settle the case anyway. They're going to try to negotiate me off of that later. Well, like pre-lit, who cares? The case is going to be different in 4 months, right? You're going to take 5 depots. They think you got no evidence. You might get a cooperating. You know what? Things change so much. Yeah, I mean, listen, I'm a realist. I've been there. Yes, it's used against you. That's why we have proposals to hide people's bargaining positions, right? Sometimes. We also have true proposals where nobody's bought into it at all. Because people really are at an impasse, but they say, well, listen to what you have to say, Kelly. You want me to pick the number when you're telling me you'd never pay more than 10 and I'm telling you the proposal is going to be over 10? Yeah, we just want to hear what you have to say. You got to be careful. Why are they doing that, right? Are they looking for a sign of what the plaintiff might take, intending to reject it? So much goes into that. Sorry, I'm jumping topics, but let me get back to my point, not talking about proposals, but fear-based conduct, right? It's normal to be afraid, especially if you're new. Right? Or if it's a huge case, or if it's a lot of responsibility, somebody's life's in your hands, or their well-being, right? Or the financial future of a company who you've worked with for 2 generations because your father was a lawyer for the company, right? The human relationship can be it can create a lot of fear. That's okay. Talk about it. Talk about it with your mediator. I'm really afraid to show anything less than this, and here's why, right?
Yeah, I have heard what I constantly hear about the plaintiffs bar in general, and this comes from both defense attorneys and mediators, is show us the goods, show us what it is we need to know. And I guess for you, it's a little skew on that, which is give us the information, let us know how you want us to negotiate this. I've always found being more straightforward rather than not with a mediator, and letting the mediator know where my intentions are. You guys know what to do when you go in the other room to hide all that stuff, as I take it. You guys know when you go in the other room, hey, Daniel told me, look, his bottom line is $500,000, but I'm going to have the conversation with these guys at 600,000. I've personally always found being forthcoming, especially with evidence. I certainly don't hide anything from the mediator. Has been the way that's worked for me. Let me know if you think otherwise, but it sounds like we're on the same page. What about
one clarification though?
Sure.
There are many mediators who would, but I would not do. I'm not sure how your example is really set up about going in the other room, but I will never say something that is untrue. But if you said, I want to communicate to them that I would never take less than 600,000 when you really would take 5, whatever that version is, I'll say, he's saying this, right? Whether you believe him is up to you, right? I will say that part, but I will not make a misrepresentation. Right? Because my trust is there are mediators who will, right? They, if the mediator believes it's to force a settlement by any means necessary, they may lie to your face, manipulate stuff, make up evidence. People do this stuff, right? It's not me.
I think what I meant to say is that mediators are good at dressing up a situation such that you can avoid ethical qualms, I think, like you mentioned, while nonetheless maintaining protecting the things that I want protected, protecting the information
sure.
I want. I think that's the whole point of having a good mediator, is they know how to, on one hand, convey information, even convey bottom lines or threats or concerns or whatever it might be of future litigation. But you guys do that in such a fashion where it just seems wrapped up very professionally. And I just give all the stuff to the mediator and I say, look, please wrap it up with your wrapping paper, do whatever voodoo it is you guys do. And things seem to work out. My cases are also pretty worked up. So that's helpful. Let's talk about briefs, because like I said, my cases are worked up. Worked up means 8 declarations and 10 exhibits.
Good for you. You're already doing more than most.
Well, I appreciate that. But I have had on more than one occasion the mediator say, I had a word with my wife about your mediation brief. It was so long. I was reading it last night.
You can keep the brief short and say, here's 8 declarations. Here's what they say in general. Take a look at them. Right? Literally, that's all. That could be your brief right there. 1 paragraph. 8 witnesses witnessed this, perp do this, and that. Over the course of a year, he did X, Y, and Z. Culminated in this incident. Here's 8 declarations about it. We want $1 million or whatever, 2 million, whatever, right? That would be a freaking amazing brief, right? Unlike the briefs that I usually read, under the Fair Employment and Housing Act, employers are prohibited from discriminating based on prohibited category, right? We have McDonnell Douglas burden shifting.
Hi guys, the lights just went out in my office, so we had to pause the recording, but let's hop right back into it. So Kelly, we were discussing plaintiffs' briefs, and you were telling us how much you love plaintiffs who include a bunch of the law in their briefs, because you don't know that law, right? You've never heard that law before.
Oh,
you don't know
man.
what FEHA even stands for.
Oh, just leave it out, please. It doesn't bother me, but I don't read it, right? Like I don't, you tell me what the black letter law is on discrimination. I don't need to read that unless there's something nuanced in the case, right? I'm scrolling down. Labor Code, 512 says this. And all right, why did they violate that? Tell me, right? I'm going down, and oftentimes the switch in the brief from statement of law to application and what happened there happens in the same paragraph. So I got no signposts. Start it on your next paragraph and say, here, the employer did this. There's four witnesses that say the defendant ran the red light or whatever, right? So give us some signposts. But the truth is, if you're going to a skilled mediator, you don't need to put in black letter law. Put in nuanced stuff, right? We just had a class action in the construction industry where there was an issue that usually doesn't come up. Well, actually it does, but it's not, in the classic wage and hour case, which is at what point does the distance to the job site become so far that it becomes non-compensable, because it's like saying on a long-term project, hey, effectively your job is to work 6 hours away for the next 8 months. So if you want to move there, you can move there and do it. We're not paying you for it. Versus, it's an extra hour longer commute than your normal employment would be, but it's going to be for a period of time. This is actually not settled, right? It's actually interesting. There's really, so that, brief that up. That's not a typical thing. If it's the pay stub didn't list the overtime rate or the number of hours, you don't need to tell me what 226 says, right? For example, that's for the non-employment law, Labor Code section 226, right?
I was going to say, do you want us to list out all the 226 violations in that case?
Right.
Kidding.
Right. Now there is a little bit of difference in if you're doing tort and you got like Privet doctrine or something. You could state the Privet doctrine if you want in one sentence. Okay, I don't care. But that's something where you'll need a lot of briefing on cases because the situations are just so bizarre that come up. Right. But I think you get what I'm saying.
I do. And it's a good thing to hear, keeping out some of that superfluous information. Sadly, the last brief that I wrote that caused the mediator to point out that his wife was upset, that he complained to his wife about it, had no law whatsoever. So that's how thick that one was. It was just dense.
By the way, you're making me think of something, which I know you're going there anyway, or you should be right at some point, which is sharing. Sometimes I'll get briefs that are awesome. They're so well written. They're so persuasive. They're so filled with good info. It makes me go, oh shit, this other side is in trouble. And when those are written like that, and it's clear that a lot of time was put into them, sometimes I think, why are they just sending this to me? Why is I the audience? It's so well done. You should send it to the other side. Yeah. And I'll tell them that, hey, send the other side. This is so good. You want them to hear this for the first time, translated through me at a mediation? I mean, yes, a lot of times they do, right? We've got the reactive devaluation. If the enemy says it, of course they're going to say that. It can't be true. They're lying. We got a lot of psychology involved. But I practiced for some time with a very like a superstar lawyer, and others who's just their SOP was we never share briefs. In fact, I just had a defense lawyer last week. I've never shared a brief in 30 years. Kelly, you're saying, to his credit, Kelly, you're saying we really need to do it here. Okay, we'll do it, right? Because there was a big disconnect and there was information the defense had. I felt that was super material to the evaluation that it did not appear the plaintiffs had based on my reading of the briefs, right? And I didn't, I don't want sandbagging. I don't want surprise on a big issue. Send it to them now ahead of time. So if there are questions and issues to flesh out, do it, right? But share your briefs. It's your ability. And by the way, remember, your audience is not necessarily a defense lawyer, right? It could be a carrier. It could be a corporate board. It could be some chief legal officer somewhere who has to brief someone else, right? So sending a brief can allow your positions to get in front of a lot of different eyes that you don't have access to normally. So do it. Share your briefs.
Yeah, it's interesting you bring that up. I had a case that settled last year, sidewalk trip and fall, broken knee, thoracic outlet syndrome, those types of things. And of course, the homeowners were involved. I'm sure you know this. California has this weird law where the homeowners that are adjacent to the sidewalk are responsible for the sidewalk, even though they don't control the sidewalk. Sounds like a bit of a scam to me, but okay. The government's just like, well, we can't deal with all this.
We can't fix everything, so there's some duty on you to,
It's silly. The homeowner has no control over the sidewalk.
So yeah, lawyers, if you're listening to this podcast and you don't do this kind of law, research what Daniel's saying, and if you got a problem outside on your side, put some cones up, notify your city to come fix it. But even while you're waiting for that, flag it and make everybody aware. There's a guy in my neighborhood who has signs all over this tree in big red that you can't miss it. It says, "I highly urge you not to park under this tree. Limbs fall off and break cars and all this stuff." And I'm like, oh, pretty cool. I wonder if that guy's a lawyer.
Yeah, or a former defendant for that matter.
Yeah, right. Yeah, right.
But in that case, so there was 3 defendants, 2 private, 1 public. It was a city, and the mediator came to me. You know who the mediator is. He came to me and said, "Look, I need to share your brief with the city." And I said, "Ugh, any plaintiff's attorney, automatically you're going to have some hesitation there, right?" It's the second time ever a mediator has come to me and asked to share my brief. I assume I'm doing a good job if that's happening, I guess. But yeah, we shared it. At least we shared some parts of it. Just for fun, I also extended parts of it, blacked it out, and pretended like it was more than it really was. But you have some fun. There's some gamesmanship.
He's letting out some of his secrets, guys.
Yeah, exactly. I pretended there were secrets that didn't exist, and then I blacked them out. It settled. It worked. The adjuster from the city or whoever it was ended up reading those portions.
Yeah.
And the case settled. I think part of the problem was the city's attorneys are so overwhelmed that they put so much work into the case. They had to see it from my mouth to get an idea of how much work that was really coming their way. So let me ask you, what's your take on declarations, especially in employment cases?
They are hugely important. Hugely important. I feel bad sometimes. I can't tell you. I even have a note to say this on this podcast, so I can hopefully wake some people up. The number of times the plaintiff's lawyer is calling a witness for the first time ever at the mediation would shock you. All the time this is happening. You never picked up the phone and called somebody? Guy worked there for 20 years. He's got some cell phone numbers. You want to find a friend or two who can tell us whether or not the boss was mistreating him this way or whatever, right? You got to get declarations. Lock those people down, right? Lock them down. Get the good testimony.
Is it more, because you brought up phone calls, is it more valuable if because I've offered to mediators, hey, you want to talk to my witnesses? So far, no one's taken me up on it.
It's not our job to get out of a witness. See, at that point, I'm the one who is eliciting the type of information that might be helpful for you. And maybe you are not the figurative you, the generic, whoever the lawyer is. They may not be able to do that, right? I can't help them litigate their case.
I understand.
You follow?
Okay.
And you are, there's a vast swath of skill out there from incompetent to highly competent, right?
Yeah.
And I can't help you litigate the case, but it happens too much. Declarations are key, especially where the employer thinks you can't prove anything.
Interesting.
Right? Which happens all the time, right? They sincerely believe what you say happened didn't happen, right? They're not faking it. They really think that what you say happened didn't happen. But you've got the one person who no one else has talked to who saw it, right? Why wouldn't you? Now you go to a mediation, you just tell them, oh, I've got a witness who's going to say X, Y, and Z. And half the time it's like, well, you can't say their name, mediator. I'm like, they're not going to believe you, right? And even so, it hasn't happened yet. We don't know if they're going to show up at a deposition and say that. Lock it down a declaration. Oh, they've already said it. Here's the testimony, right? Now, of course, they can always push back and whatever, but Lock it down and give it to them way ahead of time. In fact, I wish I could. I know I can't. Lawyers are crazy busy, right? I know. I was very, very busy in practice, all the time working. I wish I could give a 30-day minimum, if not long, even earlier mediation briefing deadline, just to force people to trade info earlier. Of course, I can't. That's not the way the real world works. But if you've got something like that, consider giving it to the defense early, right? Get that in front of the carrier's eyes or the decision maker's eyes. Because if I've seen many situations where a very honest and good defense lawyer is really trying to figure out what happened, and everything they are seeing and hearing says it didn't happen, but some of the people they were interviewing lied to them, right? And so they report up to a carrier or, a board of directors in some other state. This is what our findings are. We've done an investigation. We don't think this happened. So we're requesting settlement authority for this mediation of this, right? Versus, hey, the plaintiff's lawyers have done a lot of work. They've secured 4 people who are eyewitnesses to X, Y, and Z. Some of them are not great witnesses, but they still say some things that trouble us. And there's this witness and that witness who really surprised us. We didn't know that was coming. And they don't work here anymore, so I didn't track them down. Now look at what's coming at you, right? And they gave us a brief. They think the case is a big case. We need authority of, that, right? So just think about it. Of course, there are times when you're not going to want to do that for your strategic reasons, but do it whenever you can. Now your business may not allow you to do that, right? There's your business in particular, Daniel, is probably kind of like mine. It's lower volume, but there are lawyers who come in who have 300 cases, right? The first time they're really talking to their client is the day of the mediation, because the person before was an intake clerk, and then there was a lawyer who just drafted complaints or whatever. So I get it. The nature of your business and your own employment as a lawyer may make things difficult, but man, especially in wage and hour class actions. I mean, in every case, but man, wage and hour class actions, when the real distinction is what happened in the employer's policies, they're perfect on meal and rest breaks, versus what happened in the field. The supervisors never let us take a break. Really? Who's going to say that? Well, I'm sure they're all going to say it. Yeah, but how do you prove that now? Because they think that didn't happen, right? It's critical.
Got it. It's an interesting thing that really ties in to my February mediation, which is there are 2 specific things that opposing counsel has not done. And I think it's material evidence. And I don't know, I have witnesses that are liability witnesses. They're all listed in response to Form ROG 12 series. I don't remember which one it is. I think 12.1 or 12.2. They're listed. I have declarations from those particular individuals, and those individuals feel very strongly about the defendant in a negative way that is very persuasive to me. They're making independent allegations that mirror my client's allegation. Not mirror, they're identical. Opposing counsel has not subpoenaed any of them. That's a little strange. These are my liability witnesses. Okay. Another thing, there was an instrumentality involved in this particular injury, and they haven't asked for certain photos of the instrumentality. Now, they've looked at the instrumentality years after it was initially used, and it looks different now than it did back then. I have photos to give them.
Right. They didn't give you the form ROG general that says, do you have any diagrams or pictures or anything else?
We provided everything they asked for in the RFPs. They asked for photography of the instrumentality. We provided some photography. They never asked for a specific type of photograph. Okay. I'm just thinking to myself, I'm just going to send. Trust me, I'm not trying to withhold this. It occurred to me, they never asked for, without revealing what the case is, a specific type of photo of a specific part of the instrumentality. They never asked for it. And I'm thinking to myself, they need to
send it. Yeah.
Yeah. So I've been trying to get the defense attorney on the line. That's why I'm thinking about reaching out to the adjuster to show you, just, from an attorney's perspective, not that you lack that. You were an attorney. You still are an attorney, but you were a practicing attorney. Sometimes even in trying to get to where you're talking about going, I have difficulty getting that cooperation, at least in this one case. The defense attorney, I don't think he's rude or mean. I think he's overwhelmed. And as a result, I'm getting a non-responsive feeling from him where simultaneously, hey guys, in 4 or 5 months, we have a mediation. You need this information. I don't want to go to mediation. The reserves are set. And then I hit them, bam,
Right.
with new
Right.
evidence. We'll say, well, we got to reset.
Right. Think of this might be one way to frame it in the figurative your mind, not you in particular. If you are newer to this field, look up the law on policy limits demands, right? When a rejection of a settlement offer within policy is made, was it unreasonable at that time based on what they knew? It's hard to say when the other side hasn't done anything yet and hasn't investigated, right? So oftentimes your policy limit demand, all the time, in my practice at least, it's many, many pages long with lots of evidence attached, right? Here are all the pieces of evidence that you need to evaluate this and to show you why. You don't just have some minor reasonable probability or whatever. You've got an overwhelming probability of a massively excess judgment, right? And here's why. Right? Lay it all. If you know that that's what you have to do in a policy limits demand, why not do something like that in a mediation brief, right? And maybe tone it down, right? And say, hey, in case you want to talk about any of this before the mediation, we feel that this is a huge case and here's why. And I don't know if you've seen this yet, but I want to attach some key pieces of evidence and discuss it with you. Here's why I think this matters and why you should be coming with authority of, $1 to $3 million or whatever, right? I don't know. Frame it however you want to frame it. It's going to depend on your case and your relationship with the other side. But yeah, give them the evidence. If it's going to help you and if it's a big, if it's really important and it would shift the value of the case, well, doesn't do you much good for them not to see it.
Yeah.
Right.
Yeah. No, look, I agree. I'm on the same boat. I was trained, like I said, when I did not did the defense work. I never did defense work, but I've been trained by the insurance defense through people who've just been very kind to take me under their wing. And they always said, you guys don't give us the evidence for us to set our reserves. And here I am trying to give them the evidence.
Yeah.
Oh, goodness gracious. Look, I'll get through. And this podcast is a motivation to get through. I'll get the defense attorney on the line one way or another. Let's talk about
it. By the way, worst case scenario is the first mediation is a stepping stone to the second mediation.
Yeah.
Right. And you get the people there, the decision makers there, because they're on Zoom, so they can attend, right? They see the information for their own eyes for the first time. Hey, I've been trying to give this to you, but here it is. Okay, we need to go back and roundtable this and talk about this. Get back to you in a month or whatever, a couple weeks. So
yeah, and look, just another something that I can add for a mediator as a plaintiff's perspective. Part of me is, are they being incompetent by ignoring the liability witnesses? Could be. I usually attribute things to incompetence before any conspiracy. And incompetence is probably caused by just being overwhelmed. I don't think the defense attorney is incompetent. He probably just has too much on his plate. However, there's another thing that goes through my head, and this follows me along into mediation. Maybe they're just planning on paying. Maybe they already know about the liability.
Mm-hmm.
And that's why they're not investing money into tracing down these witnesses. So again, I think kind of what you and I are getting at in the big picture here is there has to be a communication. Obviously, there might
don't assume, right? Don't assume.
Yeah. There has to be communication here between the parties. So I am remotivated to get on the phone. Okay,
good. By the way, there's another option, which is regardless of the case, maybe they don't know the full what they're facing. But it's the MO to just get you in there and see if they can buy you out on the cheap in any case. As you know, there was one of the major firms whom I know I won't name names, had a policy of offering early mediation on like every single case. And, I've been on the receiving end of those offers, said, no, sorry, no thanks. It's too early, right? Because I know you're not going to do anything to prepare and you're trying to get rid of cases for low value. That's not this one. If you want to talk about it, let me know, right? Kind of thing. So that may be what they're doing too. Who knows? And you got to get out of that dynamic.
Yeah, I think a phone call would be helpful there. Okay, let's talk. You've been very generous with your time, by the way. We've gone about an hour.
I am here for you and your friends and colleagues on both sides of the aisle.
There's a bunch of people who I will forward this podcast to are very much so going to be looking forward to hearing you, Kelly. You have a little fan club amongst the bar here.
Well, thank you.
Yeah. Real quick, and I know you've been generous with your time. Viking Rivers Cruises. Could you take just a moment to explain the holding, and then we'll get into the substance of it?
Sure. Well, it only matters if you're doing PAGA cases, right? So for a long time, the law in the state of California was on a Labor Code Private Attorneys General Act of 2004 case, also known as PAGA. It's Labor Code Section 2698 et sec. If you don't know what that is, you can take a look. It allowed employees to bring a case on behalf of the state of California to enforce what we call civil penalties against the employer that are listed out they're usually listed out in the labor code. Any employer who violates this section is liable for a $100 penalty for the first whatever, something like that. Lots of different labor code sections have a provision like that. But we had a case a long time ago. There's lots of cases, but the key one a long time ago, Caliper Body Works explained the difference between a civil penalty section and a statutory damage or a statutory penalty that says it gets paid to the employees. Like look at the UNRRA Act and the remedies for Ralph Act and those kinds of things. Those get paid directly to a plaintiff. But a civil penalty, as stated as a civil penalty or payable to the labor commissioner or things like that, an employee normally cannot recover. And the state of California said, you know what? We're not enforcing these. We're not actually penalizing anybody. It's not enough to coerce compliance. So they passed a law that said any private person who's an employee who had a violation against them can bring a PAGA case on our behalf to enforce penalties on behalf of the state of California with respect to all the employees who are suffering violations. So that law got expanded to it's not class action standing that you need. You can enforce penalties that were, for violations against other employees, even if they weren't against the named plaintiff. And then we got law, and most importantly, that said a PAGA action, it can't be split, but it's not like a plaintiff going after to sue for their recovery, like in a class action, right? You didn't pay me wages, give me my wages. No, since you're acting on behalf of the state, this is not an individual, your PAGA action versus all these other individual employees have. No, it's for the state. And so you can't split it up because employers were trying to say, we have an arbitration agreement that says you have to arbitrate your disputes with us, right? And you waived your right to bring other stuff in groups, joinders, class actions, representative actions. And for a number of years, the holding was, no, PAGA claims are not arbitrable. The state of California never signed that arbitration agreement. You're acting as a proxy of the state, and you can't divide stuff up and have single plaintiff in arbitration on a PAGA claim and the rest somehow doing something, proceeding in court. We don't know. Well, then along came Viking River, right, where the U.S. Supreme Court got a shot at this. And their review of the PAGA statute in the context of the FAA, Federal Arbitration Act, right, among other things, and Lamps Plus, and read the cases. There's a lot of stuff going into this, right? The holding is ultimately that there now is such thing as an individual PAGA claim versus the representative portion, which is for the other employees. Okay, number one. Number two, an employer can force the employee to go into one-on-one arbitration of the PAGA claim with just respect to the labor code violations against that one employee, right? Then what happens with all the other employees was another big question in that case. The majority said in the Supreme Court opinion, the PAGA statute does not tell us what can happen. And because you have to bring your case on behalf of yourself and, not and or, but and other employees, you've got no mechanism to do this because you agreed with your employer. You're only going to be in one-on-one arbitration. So under that arbitration agreement, the Supreme Court said all those other people, the so-called representative portion of the PAGA claim must be dismissed. Now, there was a very important dissent by Sotomayor, and she said, with respect to the interpretation of PAGA and what happens to the representative claims, we are doing our best to. I'm expanding on what she said. We're making an interpretation. PAGA statute doesn't say what to do. Guess you got to dismiss it. But she says, but ultimately that's a question for the California courts to decide. What does their statute mean? Right? What does it mean? Now we got new case. Okay, so at this point, the state of the law is you sign an arbitration agreement, you can't bring this big PAGA claim against us, right? So We now have a case that will come down next year called Adolph versus Uber Technologies, which is going to decide this issue. What happens with the rest of these claims, right? Can all of them be forced into individual arbitrations, effectively gutting the purpose of PAGA, just like they can do with class actions, right? You used to have 1,000 employees in this PAGA group. Now you've got one. Or now you've got the 7 people who didn't sign the arbitration agreement instead of all 1,000 of them, right? So big issue. And so what are plaintiffs' lawyers doing? Some are saying, you know what, we won't mediate until this is decided. Sometimes they don't have a choice because to face the issue, because the defense will file a motion to dismiss the case or to sever and dismiss the representative portion based on Viking. And then you have to oppose and file a motion to stay the case pending Viking. I have seen court orders saying, no, we're not going to do that because right now the state of the law is what it is, and we don't know what's going to happen in Adolph versus Uber. So we're not waiting until next year, right? Courts are doing all kinds of things. So you probably know about some plaintiffs' lawyers joining together, and they've got the contact info of 30 employees through their discovery and their investigation, and they file 30 separate arbitration demands, right? Things like that are happening, right? Just like they did in the class action world once the arbitration issue before Lamps Plus and Epic Systems, before that was decided. And then when it came down, right, plaintiffs' lawyers were banding together and filing, we call them, mass individual arbitration type thing. That's something that people are looking at too. I hope I answered your question. Viking, the state of the law, what might happen later. Now, of course, most people think with our current California Supreme Court makeup, they're not going to say our law in California, the result of it is there's nothing to do, right? Everything else has to go away. But what they might say, hey, the statute is the statute. Legislature fix it, but we can't fix it. Yeah. I don't know. We don't know. That's the big question. What are they going to do?
So we're all waiting. And do you know when the holding in that case is going to come down, or is it? Okay. Do you have any idea? A year, 2 years?
I don't even want to guess. Well, I would expect it's, by the summer, but I don't know.
Okay.
I'm not a Supreme Court watcher to follow what stage it's at and all that stuff. When it happens, when big things happen, I get the e-blasts. I find out it's been argued, it's been briefed and all that stuff, whatever.
Okay, fair. Well, you know what we should do? We've taken a lot of your time today. We should bring you back once that holding comes down the pipeline and continue this conversation, hear some more about your thoughts. Look, this has been for me. I'm hoping anyone who's listening, who's a litigator or participates in mediation, some of the things that you told me are already things that I agreed with, which is be communicative, maintain that element. But still, hearing you say it, hearing your perspective, hearing your twist, hearing whatever Kelly Knight perspective, whatever it is, it's very helpful. So I appreciate this is a guy who's literally looking at a mediation in February. I can tell you it's very helpful. I'm sure anyone listening at home finds it similarly helpful. So thank you for taking the time, Kelly.
Very welcome.
On today. You've been over here for over an hour, so we appreciate it.
You're very welcome. Of course. Anytime I can help you guys out and the lawyer population in general, right? Plug for if you're watching this in November of 2022, I don't know when this goes live, December 1st and 2nd, we've got the California Lawyers Association Advanced Mediation Conference, which I'll be speaking at on both days, December 1 and 2, along with lots of other very distinguished, well-known mediators and plaintiffs and defense attorneys. For example, Andrew Friedman, who's always entertaining, right? He's speaking, and John Barber, I mentioned, and other folks who are just so great to listen to. So check it out. You'll get lots of different, I'm just one guy, right? Doing the mediations that come to me, right? The cases that come to me, but you can hear the take from a lot of different people. So check it out.
Absolutely. Okay. Well, that's something I'll take a look at as well.